An exclusion clause is a term in a contract that seeks to restrict the rights of the parties to the contract. Exclusion clause, that's our topic this morning on Law Matters, as we welcome on set our legal eagle, attorney at law Anthony Williams. And do remember that if you have any issues concerning our topic, you may call these numbers 1-888-991-239H29, 931-6193, and 969-3705.
Okay. So for the layman man who might not understand what the exclusion clause is, how can you explain it to that person?
All right. An exclusion clause is basically some wording on a contract or some wording on a document or on a sign that says, mostly to the effect that the company is not liable for any loss or damage or any injury. Usually you go to some car parks.
We're going to get into the specifics.
But basically, in general, an exclusion clause is a phrase that is normally seen in some documents or on a notice somewhere along somewhere, which seeks to exclude or to prevent someone from being liable. Or if they are liable, then they limit the amount of liability. And that's essentially what an exclusion clause is.
Okay.
It exists in a contract.
Yes, it exists in a contract, yes.
Okay.
Yes.
And there are specific areas that you need to pay special attention to.
Right.
I think we had an initial discussion on this, but this is an extension of that subject. So, all right, let's go into some of the areas now. Let's start with the hotels.
Yes. Okay. Now, for example, when you go to check into a hotel, before a guest is officially a guest, they would have to sign the hotel contracts. And the hotel contracts will stipulate the terms and conditions of the guest. What the law says is that at the time when the guest is checking into the hotel, any exclusion, liability, or clauses must be brought to the attention of the guests before they register.
Okay.
So, for example, if when you are registering, there is no exclusion liability about if you should leave your coats or your jackets or that safety box unattended. But then after you have checked in, you see that inside the room, then that exclusion clause, although it is there,
it is not.
It could be properly interpreted as not being a part of the contract.
Okay.
Because you would have signed as a guest, you would have entered into the contract
without knowing.
That's correct.
Okay, so
therefore the exclusion clause or clauses must be brought to the attention of the person. Yes,
okay, so therefore, a lot of people might be able to relate to the fact that when you see, if you go to anywhere, you will see that sign that says management is not liable for any damage done to your vehicle.
Yes.
Okay, so that has to, is it a case where the exclusion clause then has to be given first hand or before say a customer or consumer enters into an agreement?
Yes.
Okay.
Essentially it, right? Yeah, that's so. So, in order for it to be valid, the courts have set out some principles. One of the principles is that it must be an intention between the person who seeks to enforce the exclusion clause, say for example the supermarket owner or the dry cleaners. The airline industry, for example, is another one. You purchase an airline ticket, but how many persons really look at the back of the airline ticket and so forth? It's not until when your luggage is lost or damaged, or something plane is shut down or something lost in the air, and then when it's time to claim liability, then all these clauses are brought to your attention and say, oh, in the event of death, in the event of loss of luggage.
You have all of that. For want of a better word or expression, we are not quite rabid supporters of reading.
Yes.
And you have these fine prints, right? And when you get like your card, when you go to the hotel, when you look at the back of it, you will see all these kind of fine prints. And as a nation, we are not big supporters of reading. And you're not going to go through all of that. It is still incumbent on you to know what the rules are, to know what you're supposed to do and not do.
Yes.
So in terms of, all right, now, in terms of restitution, in terms of recourse, is there anything that you can do?
Well, it's challenging because the law is very clear that once you have signed that document, the law says you are obligated to honor your arrangements or agreement with the other party, and it is no excuse that you did not read the document. So not reading the document is not an excuse. Being illiterate is not an excuse. Have no time whatsoever to know what you're doing on that document is no excuse. So once you have signed it, yes. But the point is very valid that we as a nation generally
we don't read.
We really don't read. Yes.
Case in point, you go into a hotel room or wherever it is, and the door is broken, unbeknownst to the hotel owners, managers, and then that is noticed. And then you let them know that, well, you are not responsible for that. Is it a case of he said, she said?
Well, no. The person who seeks to rely on the exclusion clause, the burden rests on that person. So if the hotel intend to rely on the exclusion clause, they have to prove to the court a number of things.
That you did it?
One, yes, and also that the exclusion clause or the exclusion or the limitation of liability, right, was brought to your attention, or you had reasonable notice of it. So the key thing is that the burden always rests on the person who seeks
making the claim.
to rely on it. And we want to also mention about those notices that you see on in the open lots or a car park. Yeah, especially a car park.
Yes.
Or you go to some stores, you know, and you get the ticket from the security guard or the person who is manning the entrance.
Gate,
yes. And so it is very important that motorists
read.
Yes, read it.
But a lot of people would say it's just a number. I just need to go in and go out.
Yes,
so
true.
why should I read it?
Well, put it this way: we're not a reading nation,
right?
Unlike Barbados, unfortunately. But it is incumbent on us, you know, to read it, all right? Because ignorance of the law, they say, is no excuse, all right? So the dry cleaners, for example, is another perfect, is a perfect example. When you get your ticket, or that, whatever you call it, the stub.
Before we move on to the dry cleaners, I want you to totally explain for me those tickets that you get whenever you're accessing the parking lots. Most of them would say that they are not responsible for any loss or damage to your vehicle.
Yeah.
And if you lose this card, you have to pay $500. So as far as I'm concerned, the more important thing is if you lose the card, then you pay the $500.
Yes.
In that case now, what can you do?
If what?
If you lose your car on their property, there's never normally a case that said then, well, all right, we are responsible for this. So in the case of theft or damage, you will be compensated.
Well, that's a very good scenario. And I think in cases of clear negligence on the part of the occupiers of that premises, recourse can be had, all right? Recourse can be had. In the event of very clear negligence.
But it has nothing to do with the card. That's my point. It has nothing at all to do with the issuance of the card.
Well,
yes.
Well, no, it would be a separate thing, right?
That's what I'm saying, yes.
It would be a separate thing. Once clear negligence exists in relation to the management of the property where your car is, then there's a course for that person who drove the car or who was in control of the car at the time. However, in the absence of clear negligence and anything happens, then that card can be the lifesaver of the person.
So in that event, just as Ron indicated a while ago, if it's a case where you're in that parking lot, your car is stolen,
yes.
Is it a case where management of that specific area has the liability to possibly be, to compensate you for the car that's stolen?
As I said, everything has to be looked at in circumstances, all right? So it depends on the particular circumstance of the case. But generally, once they give you that card, it is a limitation of liability or an exclusion of liability. And so the motorist would have gotten the card knowing beforehand what the intention of the occupiers of the premises are. Because once you get it, of course, as I said, we get it, we put it into our pocket.
And move on.
And move on. Our aim is to, do the shopping, transact business.
And move on.
And
Yes,
move on.
move on.
All right.
Mm-hmm.
So, but I want the public to know that it is not just simply just taking the card, put it in your pocket or your purse, and move on.
So okay.
It can have some.
So the rest, the compensation has nothing to do with you in possession of the card then.
Yes,
That's
yes.
what you're saying. Let's go to the situation where you are being, somebody a thief you.
Yes.
You're in the parking lot.
Yeah.
There's the security guard and him have him dog. Him look at the dog and the dog bite you instead of the thief.
Yes. Well, there's an interesting case that was mentioned in the Gleaner some time ago with a famous businessman, where he went to transact business at a bank. He was in the car park or going to the car park. He was issued a ticket too, right? Exclusion clause. And he was attacked by an assailant. The security guard saw what was happening, went to his rescue, and in an attempt to use the dog to ward off the attacker, the dog accidentally bit the businessman. The businessman in turn sued the
bank.
The bank. I believe it was the bank. I'm not sure. And or the occupier. No, it was the occupier of the premises. And they sued the security guard company. Well, the court ruled that the dog or the security guard saved his life, and he was not able to offer compensation. And it was not a deliberate attempt on the part of the security guard to attack him, but it was accidental. Instead of attacking and the dog was getting under control, So the point is, it depends on each circumstance. You know what I mean? It depends on each circumstance. Okay.
Okay.
But in cases where you have security guards and they carelessly or recklessly do not handle the dogs to your detriment, then they can be
different thing.
So we have a caller.
Yeah.
Okay. Good morning, caller. What's your question?
Hi. Good morning. I have an issue where I work someplace, right? And if I didn't sign to something, for example, I didn't sign to a policy from my contract to say that, like for example, that taxi fares won't be issued, right? Is it illegal?
I'm not
Is it illegal if taxi fares won't be issued?
You're saying that if it is required that you reach your place of employment at a certain time and your employers do not give you the taxi fare, that's what you're saying?
Yes.
Good.
Yes, primarily, sir.
Okay. All right, good.
Well, once an employer and an employee has entered into a contract for certain benefits, then the simple rule is that as long as you have fulfilled your part of the bargain, then in his case, assuming that there's a contract between himself and his employers, that he should get taxi fare of a certain allowance, and he has proven to the company that he has taken the taxi, then he's entitled. If he did not receive his benefits, then my recommendation for him, first of all, is to speak to the company.
So it doesn't just exist in a vacuum.
No.
It has to be a part
That's
of
correct.
the
That's correct.
contract.
That's correct. It has to be a part of the contract. All right? It has to be a part of the contract.
And then if there's no stipulation in that contract to indicate if you're late, then you're not compensated, what's the next step that person is required to take?
Keep quiet.
Quiet.
That's all. Because if you can't say to your employer that you are entitled to this benefit and that benefit if there is no arrangement or contractual agreement between you and the employer. All right? So we can't impose our fanciful ideas about benefits, right? It's all about
what's in the contract. Okay, understood.
We spoke about this some time ago, but for those who came in later today would say, you walk into a store and it says if you break it, you have bought it.
Yes. Well,
is that so? It
can be so, but there have been cases where, again, it depends on circumstances. Because if a storekeeper or a supermarket owner or any proprietor of stores or occupier pack their goods in such a way
that it's liable to be broken.
That to pull one from it, it is likely to cause one or two or a series to, in those circumstances, you may not be held liable.
You will not.
Yes.
But
in other words, the consumer must be able, with ease, yes, to pull an item from the shelf. But if the consumer, through carelessness and or recklessness, right, cause the item to be broken or damaged, then the consumer will be liable.
But then at the end of the day, it would be a he said, she said. At the end,
well,
right,
put it this way. That's what essentially
will actually lead up because
that's what, yes, litigation.
But not necessarily. Most of them places now have cameras and things and can find it.
Yeah.
Let's take another call. Good morning.
Good morning.
How are you?
I'm good.
Colleen?
Can he elaborate on the airline policy? For example, if you have a television and they told you to put it in a bag and put fragile on the bag because fragile and mark TV. And when they guarantee that it will be safe, and when you get it, it's destroyed.
Okay. Well, once...
Thanks, Colleen.
Yes. If an airline gives you certain assurances, and whether it is airline or not, as long as someone has given another person an assurance that something will happen or will not happen, then if the contrary occurs, then it means that that person would have broken their promise. So in Colleen's instance, where she was given an assurance that if the fragile tag was placed on her luggage, then she's guaranteed a safe luggage retrieval upon the arrival
at her
expected destination.
Right.
And the contrary is proven, then she has a course of action. I would also say to Colleen and to all other listeners that when it comes to airline arrangements, always look at your contract, because somewhere along the line, invariably, there's going to be some exclusion clause to say, in the event of loss, damage, etc., then the company may not be liable, or they may say the extent of our liability is not more than X dollars.
We're running out 30 seconds. I want to ask you, and we see this happening all the while. You go to the bank to withdraw some money, and as soon as you exit, you're robbed. Is the bank liable in any way?
If after you exit, no. Yes. But if whilst you are inside the bank, different thing.
Okay.
Interesting.
Anthony,
yeah.
Thank you again.
My pleasure.
Right, for all the information. Okay. All right, we're going to take a break. When we come back, we talk about Deborah now and how they nurture women when you come back after this break.